So the Fourth Amendment is the Fourth Amendment to the Constitution, and it's a particularly important amendment. It protects against the government being able to engage in unlawful or unreasonable searches or seizures. So whether that means searching your vehicle, searching your home, the Fourth Amendment means that the government needs to go to court and get permission and state why they have probable cause before they can enter into your private space.
The Fourth Amendment is an extremely important part of the U.S. Constitution because it upholds and protects individual privacy. And we should care about that because we don't want to live in a society where government can go on fishing expeditions to seek out information about us that they deem to be bad or illegal.
It really is the thing that protects our privacy from government intrusion. Whether that means the privacy of your home, the privacy of your workplace, the privacy of your vehicle, the privacy of your medical records, the privacy of your data that you put up in the cloud. These are all the things that govern and define our lives. And we need to make sure that the government isn't allowed free access without having to justify why they get to pry into our lives.
Courts have done a decent job in protecting individual privacy when it comes to data and property in your own possession. However, they have not extended that privacy to information and property that's stored by a third party, which is why it's so pertinent today that we need to protect that as a state.
When you send your information or give your information voluntarily to a third party, previously the Supreme Court has held that you give up any sort of expectation of privacy in that information when you hand it over. And therefore, if law enforcement or the government wants to come and seek that information from the third party, they don't have to secure a warrant. But increasingly, there are a lot of states that are pushing back against that notion.
So we have a new Supreme Court decision. This time, the Supreme Court decided that police need search warrants in order to take information from a criminal suspect's cell phone.
So the Supreme Court recently decided a case called Carpenter. It was a case brought by the ACLU and involved an individual who was suspected of engaging in a series of robberies. And in order to investigate that case, law enforcement went to the cell phone provider and asked for information about this individual. Mr. Carpenter's attorneys, the ACLU, contested this, and the case went all the way up to the Supreme Court on grounds that they should have sought a warrant because that sort of information should be subject to a warrant on the basis that people have a reasonable expectation of privacy in that sort of private information. The court actually agreed in a somewhat narrow decision, indicating that the court's movement in this area really is going in a direction of protecting information not just within the confines of your home or within your vehicle or sort of the more traditional notions of our own private space that we think of, but increasingly to protect also information when it's contained in these new technological ways that we keep our information, like the cloud, like a third-party remote computing service, like your cell phone provider.
When the Fourth Amendment was written in a colonial time where technology is not nearly advanced as it is today, it was protecting completely different things, such as papers and effects. But now, technology has expanded so much. We have cell phones, computers, tablets, and the Fourth Amendment needs to extend to protect those today.
There is always the possibility for states, and states like Utah, to go further and provide additional protections. We know that our own state courts have often done that based on our own history and development of the state of Utah, that our Fourth Amendment provision in the Utah Constitution, Article 1, Section 14, actually provides greater protection than the Fourth Amendment, given our history and the formation of our state.
If you think about it, we all rely on third parties to do things we expect to be private every day, such as uploading a business document to Dropbox, sending a Snapchat, or sending money through Venmo, and more.
Utah has demonstrated in the past that we are ready to take on hard issues, that we don't need to wait for the courts, that we are ready to forge ahead and be the first when it comes to protecting our citizens' private information.
If Utah implements a third-party data protection law, we'll be the first in the nation to do so. And this is a great opportunity for us to lead the way for other states to follow.